I'm John Roxon, and I'm an attorney at the Myrtle Beach office for the Joy Law Firm. As anyone who has been injured on the job knows, the workers' compensation system in South Carolina can be very complicated. There are limitations and strict deadlines which the injured worker must meet, or he may lose his right to benefits. Also, workers' compensation law is constantly changing, and as in all areas of the law, ignorance of the law is no excuse. One area which has seen changes in the recent past is the law governing what are called repetitive trauma injuries. Most people are familiar with or have heard of carpal tunnel syndrome, which is what most people think of when they hear the term repetitive trauma. It is important to know, however, that repetitive injuries can affect any part of the body, including the shoulders, knees, or back. Repetitive injuries have become accepted under our workers' comp system, and the law has changed because of that fact. The changes also place some additional burdens and requirements on the injured worker that you need to be aware of to protect your rights if you may have a repetitive trauma claim. As part of the changes to the law, a separate section was enacted that defines repetitive trauma injury under our workers' compensation system. As part of the additional requirements to establish that repetitive trauma claim under the new section, a qualified physician must state in writing that there is a direct causal connection between what the employee has been doing on the job and the injury. I always tell my clients to sit down with the doctor and give him or her specific details of their job duties, the type of activities, the amount of time each day the activity is done, the number of hours worked each day and week, how long the client has been doing this type of work, and ask the doctor to include the job description as part of his office note. Another change to the law places the burden on the worker to report a potential injury to his employer within 90 days of the time that he or she discovered or could have discovered by exercising what they call reasonable diligence that he or she has a workers' comp injury. Well, what does this mean? Certainly, if a doctor tells you that your symptoms are related to your work duties, that would meet the statute requirements and you have to report it. However, the law seems to go beyond this and require that the worker actually ask or discuss the possibility of a work-related injury with the doctor, or even go out and obtain a medical evaluation to determine whether the problems are work-related. There is also a requirement that a repetitive trauma claim must be filed with the Commission within 2 years after the employee knew or even should have known that there was a workers' comp injury. If you suspect that you may have a repetitive trauma work injury, you should consult with an experienced workers' compensation attorney immediately in order to protect your rights. Even if you are worried about reporting a potential workers' comp claim to your employer, failure to report it under these new laws could result in the claim later being denied and the loss of all benefits. So if you think you may have a repetitive trauma work injury, call the Joy Law Firm and we'll review your case for free.